the issue of state-level concealed carry bans is once again back in the spotlight. Although a significant portion of New York's law was recently struck down, the matter is now being reconsidered following the Supreme Court's decision to deny an emergency review. This means the legal challenge is now proceeding on its full merits. In this video, we're going to take a closer look at what's happening in this critical legal battle over concealed carry in New York. As many of you will recall, the Supreme Court recently issued an 8-1 decision in the Rahimi case, and shortly afterward, it sent multiple concealed carry cases from New York back down to the lower courts for reconsideration, instructing those courts to reassess the cases in light of the Bruin decision. There are two main legal challenges to New York's Concealed Carry Improvement Act, currently making their way through the federal courts. The first is the Antoniuk case, which was remanded to the district court for a final ruling on the merits. But while that process has been ongoing, another case, Christian v. Nigrelli, advanced more quickly. In Christian, the district court issued a summary judgment ruling striking down a key provision of New York's Concealed Carry Improvement Act. That provision, often referred to as the catch-all private property ban, made it a felony for a concealed carry permit holder to carry a firearm on private property unless the property owner gave explicit consent, either verbally or by posting a sign. This part of the law directly contradicted what the Supreme Court laid out in the Bruin decision, and the judge in the Christian case, Judge Sinatra, recognized that. Judge Sinatra's ruling clearly stated that this broad restriction on carrying firearms on private property, especially when that property is open to the public, violates the constitutional protections affirmed in Bruin. In response, New York Attorney General Letitia James appealed the decision to the Second Circuit Court of Appeals, which has now heard oral arguments on the matter. From what I gathered while listening to the Second Circuit hearing, there's a strong chance the court may uphold the district court's decision and agree that New York's private property restriction is indeed unconstitutional. In Judge Sinatra's decision, the court leaned heavily on the Second Circuit's earlier findings in the Antoniuk case, which also rejected both the catch-all private property ban and bans affecting public property. Judge Sinatra cited that prior ruling, stating, "As the Second Circuit observed in Antoniuk, no matter how expansively we analyze, we do not see how a tradition of prohibiting illegal hunting on private lands supports prohibiting the lawful carriage of firearms for self-defense on private property that is open to the public." Essentially, the court found that New York's justification didn't hold up. There's no historical precedent for barring lawful firearm carry in public access private spaces. Despite this clear ruling, Attorney General Letitia James again appealed to the Second Circuit, pushing for a reversal of Judge Sinatra's decision. That appeal has now been argued on the merits before a 3-judge panel. After listening to those oral arguments, it appears that at least 2 of the 3 judges may side against the state. One judge questioned whether the catch-all ban is overly broad, noting it fails to make meaningful distinctions between the types of private property the state is attempting to regulate. Another judge directly asked, "How does this law not categorically burden the right to carry?" That same judge also referenced Judge Van Dyke's dissent in the Wolford case from the Ninth Circuit. In that dissent, Judge Van Dyke raised concerns that laws like these essentially confine lawful firearm carry to sidewalks and streets, stripping citizens of practical self-defense rights. That sentiment seems to resonate with at least some members of this Second Circuit panel. The arguments also explored New York's historical justification for the carry ban. The state leaned heavily on outdated hunting laws and 19th-century statutes, some of which were explicitly used to disarm African Americans. We've seen states like California attempt similar justifications in the past, and now New York is following suit. But judges on the panel strongly pushed back on that reasoning. One noted that those types of discriminatory laws have no place in modern constitutional analysis. Another emphasized that the old hunting laws cited do not justify a blanket ban on lawful carry for self-defense, especially not in places open to the public. The panel made it clear, using racially discriminatory or unrelated historical laws to justify today's sweeping restrictions is not a valid legal approach. There was also an important discussion comparing how constitutional rights are treated. One point raised was that we would never accept a rule under the First Amendment that required people to obtain express permission from a property owner before speaking freely in a public-facing area. Yet here, with the Second Amendment, the state is arguing that people must get express consent just to carry a legally owned firearm. This contrast highlighted the inconsistent way courts and legislatures often treat the Second Amendment, as if it's somehow a second-tier right. Finally, the panel addressed whether the earlier Antoniuk ruling, despite being a preliminary injunction, should be treated as binding precedent. The judges weighed whether that earlier decision, which already declared the catch-all ban unconstitutional, should guide the current case. The pro-Second Amendment side argued that if the Second Circuit already found this law unconstitutional in a preliminary ruling, and now that the case has been fully briefed and reviewed on the merits, just like Judge Sinatra did, then the outcome should be the same. And with more detailed historical context now developed at the district level, the argument is even stronger. New York's catch-all private property ban violates the Constitution. After listening closely to the arguments, my overall impression is that things went fairly well for the pro-Second Amendment side. At least two of the judges on the panel seemed likely to agree with Judge Sinatra's earlier ruling that the catch-all property ban in New York's Concealed Carry Improvement Act remains unconstitutional. Now, it's possible the court may uphold some parts of the law, but because this case is being reviewed on its final merits, it could be positioned perfectly to head to the Supreme Court for a full review. This would give the court an opportunity to directly address these carry bans that were clearly passed in defiance of its guidance in Bruin. Currently, there's also the Wolford case out of the Ninth Circuit, which is seeking emergency review from the Supreme Court. However, that case is still in an interlocutory stage. It's based on a preliminary injunction, not a final ruling. One encouraging sign in that case is that the former Trump Department of Justice has urged the Supreme Court to take it up and strike down these laws for what they are, a blatant rejection of the Bruin decision. If the court were to take up the Wolford case on an emergency basis, it could create ripple effects that would also impact the Christian case here in the Second Circuit. That said, the court has consistently declined to take up these types of interlocutory challenges, so it remains uncertain whether it will act before a case like Christian reaches them through the usual process. So this case is one we'll be watching very closely. It's one of the most advanced challenges against New York's carry law and stands a strong chance of eventually landing in front of the Supreme Court. Unless the justices decide to act sooner in Wolford, Christian could be the case that sets the stage for a major decision on the merits. As this continues to develop, I'll keep you updated with any major changes or rulings. If you found this video helpful or informative and want to support the channel, one of the best ways you can do that is by liking the video, leaving a comment, and subscribing if you haven't already. Thanks again for watching, and I'll see you in the next update.